understand how a living trust works and the advantages of a trust over just a will. Get ready. In this episode, I'm going to explain 6 distinct advantages. There's several, but there are 6 that are really the most important to me of why I believe that most people should have a trust over just having a will or no will, which is deemed a dying intestate if you don't have a will, because the state has a will for you. You may not like that one. So I'm Doug Andrew. I've been a financial strategist and retirement planning specialist now for 5 decades, helping thousands of people in America optimize their assets, minimize taxes, and empower their authentic wealth. But in doing that, as I've helped many people accumulate a lot of assets and wealth, there's a need to protect it, especially in this sue-happy society we have become, and also protect it from unnecessary estate tax and what have you. Estate tax is sometimes referred to as the inheritance tax. And depending upon the tax code of the time, back in the 1990s, any value of your estate over $600,000 started to be taxed at, I think it was 37%. It topped out at 55%. As of the recording of this episode, now the exclusion is substantial. President Joe Biden, to cover deficits, he wants to probably lower the exclusion back down again, maybe to $1 million or $2 million, and then take the estate tax up to even 67%. And so at times, based upon how much the government revenuers want to go after money, because they love to tax people who were 6 feet under because they can't complain about it. So let me, in this episode, try to explain things as simple as possible, because things like an estate tax or anything that has to do with distributing assets, sometimes that does not get any type of a tax consideration until after the second death. In other words, in America and in most states, it isn't until the second death between a husband and wife, the first death, and then the second one, that all of a sudden within 9 months, you have to file, I think, what is called a 706 form with the IRS, and you have to list all of the assets that were owned by the deceased, all the way down to, their underwear and what it was worth and so forth, so that they can determine if there is an estate tax due. And that form is due within 9 months after the death of the second in a marriage. And it's based upon the value of the assets at death. So it's wise sometimes to get, things valued, appraised, or what have you at death if you're going to be filing these forms later and you want to establish basis, acquisition indebtedness, if you want to calculate the tax based upon the value at the time of death, if that was in the middle of a recession or whatever, okay? So let's go through some basics of how a trust works and why it's very important, I think, to have one even over a will. It's not just a function of having assets. A lot of people will want the advantages of a trust even if they don't have a large estate. So this little cartoon I love that my attorney shared with me, Mr. Frosty, it's March. Time to talk about estate planning. It's amazing how many times people don't really start thinking about this until late in life, and here the snowman's about ready to melt, about ready to, go the way of the world, and it's time to start looking about estate planning because he's going to melt away. You want to get this done while you have sound mind, is my opinion. I think most people should do it even when they're young in case of an untimely death, an accident, or what have you, because you want to include certain things in the trust that sometimes people just think a will do. Basically, if you have a will, that means that you are going to name who gets your things after you pass away. And in a will, you can name the guardian of minor children if you happen to die and you still have minor children in a will. If both you and your spouse were killed in a common accident, then you can designate who you want to be as guardians to your children, who's going to raise them and what have you. A will, if you want to get specifics about who inherits, Grandpa's gold watch or Aunt Effie's vase or whatever, you can do that in a will. But many times people die without a will. That's called dying intestate. And they think nothing's going to happen. Well, if you die without a will, the government, the state where you live has a will for you. You may not like what they say or who should be the guardian of your children. People usually want to make their decisions instead of having the government make decisions. And so you want to have a will. Now, if you have a will, there's a saying, where there's a will, there's people say a way. No, where there's a will, there's a probate. So let's talk about what probate is, because a trust avoids probate. Now, probate isn't all bad, because when you file a probate, one of the advantages why you may want to have a probate, even if you have a trust, is because you file a notice, a legal notice, and then any creditors of the deceased have a certain window of time, maybe 60 or 90 days or whatever, based upon probably the state they live in, that the creditors must come forth and make claims against the estate, the assets of the deceased. If they don't come forward to make a claim, it expires. And so they can't come out of the woodwork, 4, 5, or 10 years later and say, oh, your father owed me money and I'm coming after it. See, if you had a probate that had been conducted, they're out of luck. But if not, they could come after you 15 years later and open up a lawsuit against your deceased parent's estate if you did not take it through probate. So there is an advantage. That's why a lot of wealthy people will put some little worthless item to be probated, an old tractor, an old motorcycle or something, that if it was probated, there's nothing really there, but you go through the legal process. So probate does have some advantages, but there's some problems here, okay? What is it? It is the legal distribution of your assets to who you want to inherit those things under the jurisdiction of a court, a probate court. The problem with this is it often takes time, sometimes a few years, and so that's expensive. And when you go through probate, there's sort of a list of 7 people in order of priority. I think, first of all, the federal government has first lien if there's any taxes owed, and then state and then local taxes. And then you have court costs. You have attorney's fees, you have executor's fees, and then you have the creditors. And finally, the heirs are like 7th or 8th down the list. And that may take 2 years to determine that everybody's satisfied. So that process is probate. They want to make sure everybody's okay and everybody's been paid that was owed money. And so it's very public. It's not private. People don't like that. And once you start it, you can't stop it until it's consummated. And it's conducted in every single state where real estate is owned. So the way to get around it is not so much avoiding it, but it's avoiding the costs and the delays, because when you use a trust, your estate can be settled in one day, and then you only probate it in order to have a small little asset so that you can have the creditors of the deceased hold their peace after the period has expired, okay? And so when we talk about a trust, many of the attorneys, I'm not an attorney, but I have trained many estate planning attorneys on how to set up equal opportunity trusts rather than equal distribution trusts, which is another subject. But this video is talking about just the advantages of a trust. And I believe that you'll want to set it up with rules of governance so that you don't ruin your children. But here are some of the basic advantages, because if you wanted to set up a perfect trust, the structure for a perfect trust, this is the information you would need, okay? Which spouse is going to die first? You need to know when, and the decedent's state of residence. Also, the size and nature of the estate assets at the first death. You need to know what's the federal estate tax law at the first death, okay? Does the decedent's state of residence have a death tax? And then that comes into play usually with the second death. Then, does the survivor plan on moving to another state? What's the age of the survivor? And people are, well, how do I know all this? You don't. But this is what would be nice to know if you were going to set up a perfect trust. The ages and financial condition of children at the first death. At the first death, does either spouse or any beneficiary have creditor problems? This is a consideration a lot of people forget. And does the deceased have assets that are in several states? Now, if you knew all of that, then you could set up the perfect trust. But you don't know all of that. When will you know all of that? Okay. Well, you'll basically know that within 9 months of the death of the first spouse that dies. So as soon as the first spouse dies, within about 9 months, you'll know the answers to all of those questions that I'm talking about here. And so then you need to set up a trust that is flexible. I have a beatitude, blessed are the flexible, for they shall not be bent out of shape. And then you'll know the answer to these questions. In the meantime, you have to have flexibility so that when all of this happens and you know this information, you can adjust, okay? And so the flexibility is the key when you're setting up a trust. And a good attorney will help you do this rather than just maybe a boilerplate trust. There's a lot of ways that you can customize things if you have special needs children or grandchildren, or you have unique situations. You don't want just a boilerplate trust thinking that things are going to just work out. You may need to have customized rules, or like I do with rules of governance, I don't want to just have my assets divided up and dumped in their laps, because that ruins half of the kids in this country when they inherit things. I want to leave behind a system where the assets are there, they can borrow money. They pay it back. They can receive matching grants or to their scholarships for college education or for whatever. It's not just an inheritance. Oh, when do I get my share? This causes entitlement mindsets. So in my book, Entitlement Abolition, I talk about how to set up equal opportunity trusts, where you have a trust that is administered based upon rules of governance with equal opportunities, but not equal distribution, where when you die, they just chunk, divide it up and dump it in your kid's laps, because it ruins about half of the children in this country when they get this lump sum, and it takes the family from we to me. When do I get my share? It destroys the love of the family. So I use a trust primarily for preserving the love of the family, besides avoiding probate and liability protection and what have you. So let's go through what I consider to be 6 of the primary advantages of a trust over a will. There's 12 to 15 advantages, but these are the 6 big ones to me. First of all, when you set up a trust, it avoids probate. You'll still probably want to probate a worthless asset, like I say, to get rid of the creditors, but it avoids probate. The estate is settled in one day, so that saves the time and the cost of probate and all of those people that line up in order before your heirs actually get their portion, and having the court wait to find out if the IRS is satisfied, the state, the local taxes have been satisfied, the court costs, the attorney's fees, the executor fees, the creditors, and once all of them are satisfied, now the children or the heirs get it. No, you don't have to worry about any of that. Next, it avoids unnecessary estate tax. Now, back in the 1990s, for example, I remember when the estate tax started on any value in the estate over $600,000, and it started out at like 37%. On any assets above that were left behind after the death of the second spouse. And the tax rate topped out at 55%. And then they raised the exemption from $600,000 and went up $25,000 a year, and then it hit $1 million and was there for a while, and then it's gone up substantially. As of the recording of this episode, between a husband and wife, there can be well over $10 million that can transfer down exemption without an estate tax, but government revenuers, those are the ones who are spending more than they bring in. They always love, when they're short of money, tax revenue, they love to increase the estate tax or lower the exemption, because they love taxing people who are 6 feet under, because they can't complain. And the heirs are going to have to accept whatever they get. And the government argues, well, the heirs didn't earn this money, their parents did. We want to go in and grab 30, 40, 50, 60, 70% of it. So as of the recording of this episode, we've had the government spending double to triple what they've been bringing in. And President Joe Biden is president as of the recording of this episode, and he's talking about raising the estate tax up to 67%, going from about 40% up to 67%, taking 2/3 at the second death. and maybe lowering down the exemption so that maybe that estate tax will come due on any value in the estate over, $2 million or $5 million, not the amount of exemption we have right now between a husband and wife. But when you have a trust, it usually divides up the assets into a husband's trust and a wife's trust. Sometimes they're called AB trusts. In my situation, I have my own trust and my wife does, and we divide up the assets. I usually have the business assets in my trust and primarily the domestic assets in my wife's trust. And that way we sort of have double the exemption because we divide up the assets and she has an exemption and I have an exemption. So between the husband and wife, you'll usually double the exemption amount before any estate tax is due, so it usually avoids unnecessary estate tax. The third big advantage is privacy, whereas probate is public. When you have a trust, that's private. That is not public information. A lot of people like to keep their things private. I think that's a huge advantage. The fourth big advantage is it preserves the love of the family, as I mentioned before. When you just leave behind your assets and the kids fight over who gets what, that ruins the love of the family. And most parents, that's the last thing they want to do is ruin the love of the family and create a feud between their children, fighting over who gets Grandpa's gold watch and Aunt Effie's vase or to sell the assets. I have horror stories of families who, one of the children took their inheritance early. And I'm thinking of one case where a young man, he said, give me the restaurant. The other siblings all said, okay, but that's your inheritance. It's worth $5 million and that's all you're going to get. So at Dad's death, you don't get anything else because you already got this $5 million restaurant. Well, he ran the restaurant into the ground, and when his dad died, he goes, hey, I deserve 1/5 of the rest of the estate now. And the siblings won't even talk to him because he already got his 20%, but he wasted it in, so to speak, riotous living, like the parable of the prodigal son. Well, those siblings don't talk to each other as far as I know because he feels like he was cheated and the others feel like they were cheated because he got actually more than they did. And so this is why a trust is cut and dried. It lays out who gets what. The trustees must follow the instructions of the trust or they can be sued by the others, the beneficiaries. But it has a tendency to keep the family together. The fifth benefit is liability protection in this sue-happy society that we've become. It creates firewalls of protection. Like I said, if somebody sued me, they can come after maybe the business assets if the liability fell on the business. But they can't come after my personal assets or our home because that's in my wife's trust. And so in the sue-happy society, they can come after you. But if you owned your personal residence, in half of it in one trust, the husband's trust, and half in the wife's trust, and somebody trips and falls or is in an accident or something or gets hurt on a trampoline in your backyard, depending upon who was at fault, they can sue you for is the portion that you have. I had an anesthesiologist that was sued for the value of his house, but half of it was in his wife's. His wife had nothing to do with it. I had another case where the wife got in an accident. They actually let a 16-year-old drive the car on a youth outing, and they had an accident, and so they tried to sue. The most they could get is half of the value of the house. But if you own it in joint tenancy without a trust, then the entire house is fair game to go after. So when you have your assets divided up at least sort of half and half in a trust, the most they can go after is half of your assets if the liability fell upon one individual or the other. Now, if it falls on both of you, then it could be all exposed. But it helps with liability protection. I'm going to give you an illustration in just a moment about that. The last is what we call the second spouse syndrome, where many times I had a client whose wife passed away shortly after she retired at age 65. They thought they were going to retire for 20 years and enjoy retirement. He was so lonely, he remarried, and his next wife said, show me you love me. Prove to me you love me. Put everything in my name. Well, I was the successor trustee on his previous wife's trust. He was really angry with me because I wouldn't do that. I couldn't do that. But he gave all of his assets and put her name on it. And as soon as she got as much as she could, she said, bye-bye. And he lost everything that he put in her name, but he was so grateful and was thankful that I didn't, violate as a trustee of his first wife's trust, because he still had those assets. But so many times a person will get remarried, and then if you don't have a trust, then the new spouse, when you die, the new spouse and all their children gets all the assets, and your children, your blood relatives, they get disinherited. This makes sure that your blood relatives, your descendants, don't get disinherited if there's a second marriage. Does that make sense? So those are the 6 big advantages out of probably 18 to 20 that I could list here on the screen. But when I teach about asset protection, this is a chart that my attorney uses oft times. He prepared it. So this could be Rick and Dorothy Smith estate. So they have a husband and wife trust, or maybe the husband has a trust, the wife does like I do. And this prevents the probate, unnecessary estate tax, keeps things private. But then you might have a family limited partnership for non-retirement investment accounts. This is where I keep my laser fund, and I keep it up in Alaska because that's next to impossible to penetrate in courts of law. And it's also very hard to penetrate money inside of a maximum funded insurance policy. And then maybe a home might be in a Wyoming LLC because that doesn't have a state tax. And then you might have LLCs down here, individual LLCs that give you liability protection, maybe for a cabin, a commercial building, boats, motorhomes, or whatever, because the most they can sue you for is the value of that asset. If you have a lot of rental properties, frankly, I don't think it's overkill to have all of those rental properties in separate LLCs in case they sue you. The most they can get is the value of what's in that LLC. If you only have one rental property, the most they can get is the value in that one rental property. But if they go to sue you and you have like 10 or 20 rental homes in the same LLC, they're going to go, hot diggity dog, look, I got 20 properties and look at all that equity. Now, this is why I have separate LLCs for every asset, even separate rental properties. And I keep all of them mortgaged to the hilt, and I keep the equity up here in an Alaska trust in an insurance contract. And it's next to impossible to penetrate in courts of law, and I earn double to triple the net cost of the mortgage down here. But an attorney who has over 10,000 clients in California said, Doug, you solve a problem that I try to solve, as an attorney for decades. Who's going to sue you for your assets or your equity in your real estate if it's not there? If it's up here in an insurance contract in Alaska Trust, it's next to impossible. They won't even, it's not worth their time. And if it's mortgaged to the hilt, there's nothing there to go after, so they don't go after you. This is critical. Last of all, you might put your IRAs or 401ks up here in another holding company. But there's all kinds of structures, if you go to a good attorney, that will give you asset protection. You have your LLCs. That builds firewalls of protection. They can only sue you for the value of the assets in that one. And then you keep their assets in the holding companies, and then they're under the actual living trust. This is sort of how you protect your assets. So there's a lot of reasons why you may want to consider a trust set up correctly to avoid probate, unnecessary estate tax. But the liability protection, I think, is really, really critical. If you want to learn more about this, we're not a law firm. We can point you to law firms who understand how to do this correctly. But I would recommend, first of all, you study my book. This is where I keep my assets because they're protected just because they're some of the best places to accumulate money, and they're creditor proof. If I die, anything that's in my laser fund blossoms and transfers tax-free, and that money is not subject to the claims of the creditors of me if I die. That is already included in the value of life insurance. But it's also next to impossible to penetrate the cash value inside of insurance policy based on rules. You need to learn this. So study my book, The Laser Fund. It's been flying off of our warehouse shelves. It retails for $20 on Amazon plus shipping. If you buy one on Amazon, thank you, but I'll gift you a copy free. It's 300 pages. It's actually 2 books in one. This side is 200 pages with charts and graphs and explanations if you're a left brain learner. If you're a right brain learner, you flip it over to this one. This is about 100 pages, 12 chapters with 62 actual client stories. And I give some stories in here of how these have helped people protect their assets. So I'll gift you a copy free. You just can contribute a nominal amount towards the shipping and handling by going to laserfund.com or click on the link below. And while you're in there contributing to the shipping and handling, I'll cover the rest of that cost. I'll pay for the book and fire out a hard copy to you via priority mail. When you're in there claiming your copy, if you'd like to listen and learn or watch and learn, there's audio and video formats. Check those out. You can even register for a free educational webinar we do on a regular basis. Also, you can schedule an appointment with a specialist that will show you how to set up a laser fund in your particular set of circumstances. No cost, no obligation to you to see how these strategies may apply for you. But this is about you and your assets and protecting those things that you've spent a lifetime accumulating. And I want you to be able to understand how to do that and the advantages of a trust over a will.